let's talk now about additional ways to shut down foreclosure. So this is what I need you to do for me today. I need you to list out all of these and make sure you understand them. So let's say you have an attorney or somebody else helping you. One of the problems I have going behind attorneys, which frustrates me sometimes, and I'm not going to say, I'm going to say all the time, they understand standing and capacity. And most of the time, attorneys make an excellent argument for standing and capacity. Sometimes it's the judge that doesn't understand, and the judge rules against you. That's the judge's fault. And some judges are on the take. I hate to be the one to tell you, but some judges are being bought off by these industries. So it's possible that your attorney maybe meant well, but he just didn't have the resources. That's why I'm giving you the list. If you follow this list, it's impossible to lose your home to foreclosure. This is the recipe to save your home. If you lose one of these, you go right to the next one. And you keep filing motions indefinitely until you win. Let me explain one of our strategies. So if you feel like the judge is ruling against you or he ain't listening, change your strategy. He can't rule against everything because it's all based on law and it's already been pre-argued by all 50 attorney generals in the country. So you have to wear some of these judges down. Sometimes these judges get it right away. Sometimes the banks walk when they see where you're going, but you have to be relentless. You have to be the Terminator. No matter what happens, I'll be back. We do this with all of our clients. You know, sometimes they get discouraged early in, they lose round one and they get discouraged, and I have to encourage them, don't worry. We're going through all of these until we win. So the first one is standing in capacity. Make sure you understand what this is and what this means. Standing in capacity. So standing is your right to foreclose. In America, in order for them to foreclose, they have to prove that they own the mortgage and the note. And you think, oh, of course they can do that. That is difficult. If the mortgage was before 2010, it's almost impossible to do. They can't proof up their claim. You think it's easy? That is not true. And so you have to push the envelope. So most attorneys are reluctant to really push this and force them to prove it to you. But you have to challenge standing and capacity. So the standing means you have the legal right to initiate a foreclosure lawsuit, which means at the time of inception, you own the mortgage and the note. Mortgage and the note. Mortgage and the note. You have to have both. During every mortgage before 2010, there was a separation of the mortgage and the note. The notes were fractionalized and sold off, and then the mortgages, they sold those as well and made even more money off those. So they separated the two. So recombining them is extremely difficult. So what's funny, I was looking at a foreclosure case today, and the attorney was arguing, oh, we proved that we have standing because we attached a copy of the note. But they conveniently forgot to mention that they didn't attach a copy of the mortgage because they don't have possession of it. But if they argue hard enough wrong stuff and your attorney skips this very valuable stage, then the judge, because you didn't deny it, he will agree with them and you will lose. I need you to have standing, which means you have both the mortgage and the note. Once you have standing, I need to know, and this is crazy. This is going to scare people once you understand this, capacity. They have to have the capacity to sue. Capacity refers to a party's legal ability to participate in a lawsuit. That sounds crazy, right? Let me explain to you what that means and why we never lose. Because most entities that are suing you don't have the capacity to sue. So let me give you an example. In order to sue in the state of New York for any debt, you have to be listed with the Secretary of State. In order to, additionally, in New York and some states, you have to be listed as a debt collector. So as soon as you're not listed as a debt collector in that state, or you're not listed with the Secretary of State, you are automatically prohibited from foreclosing. Let me give you an example of that, which we destroy people with. Let me give you an example. So recently, where we overturned a couple foreclosures, they were against U.S. Bank as trustee for, you've seen it, for blah, 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 right? Because you're not arguing, or your attorney's not arguing capacity, I'm going to show you one of the greatest cases that we won, and it was won solely on the capacity issue. But you say U.S. Bank as trustee is suing you, so everybody knows who U.S. Bank is. Of course, U.S. Bank has capacity. They're a national association. They're a bank. Wrong. You're not being sued by U.S. Bank. If you were, they would say U.S. Bank. They don't say U.S. Bank. They say U.S. Bank as trustee for blah, 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 blah. That is a separate entity in and of itself, and it is a separate corporation. That corporation has to have the capacity to sue, and they never do. They have to be listed with the Secretary of State as U.S. Bank trustee, blah, 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 blah. They can't be. U.S. Bank N.A. is a different corporation. Do you understand? U.S. Bank is completely different. Unless you're telling me that U.S. Bank owns the debt, that I can understand. If you are, and you have to raise this argument just like I'm telling you. If U.S. Bank is who I'm going up against, simply change the caption and say U.S. Bank. Now I know how to attack this debt, because now U.S. Bank has to proof up that they own the debt, which we know they can't do. They use a fake corporate entity because they know you're not going to challenge capacity. Your attorney's not going to challenge capacity. Get out of here. So they use a fake entity because you don't challenge capacity. Please, let's keep going. Here's an example. Okay, this is it. So this was what I consider our greatest victory. This client owns a penthouse in Manhattan, worth I think 10 or 20 million bucks. They had a very small mortgage, maybe 3 or 4 million, which they defaulted on, and the house was up for foreclosure. Now, this was their long-term family house, which he had inherited, and now it's going up for sale. So this client automatically, he lives in Manhattan in a penthouse. So the first thing he did, he went to 2 Wall Street law firms to save his house. The first law firm lost the house, told him he had to get out. He went to a second law firm. Each one he paid close to 100 grand to 200 G's. Both of them lost. The second law firm said, you got 2 weeks to get out of your house. We lost. So man, this is why people hire either terrible lawyers or they don't hire anybody, because they're paranoid that you're going to pay somebody $250,000 to save your house and they're going to lose because there's no guarantee, right? So you can see here, it says the defendant now moves for order pursuant to CPLR, granting renewal of his motion to vacate. So he's already lost through another law firm came in did a motion to vacate, which we talked about earlier, and they lost, which I told you that happens. This is a Wall Street law firm, and they lost the motion to vacate. They lost it. So now I'm going back to the same judge and saying, I know 2 Wall Street law firms argued this case. Both of them, you denied their motion and threw it out. But now I'm coming back, and we did this case pro se. So the client came back without an attorney. We just had one of our legal department, one of our attorneys prepared the paperwork based on my strategy. And so now he's going back without an attorney, facing the same judge after losing with 2 Wall Street law firms. So you see, now he's asking to grant a renewal of his motion, originally filed October 1st and previously denied by the court on October the 10th. The client was paranoid and crazy, but he was referred to me by a good friend of his who said, trust Dr. Grayson, he has never lost a house. This guy was like, I had 2 Wall Street, the best law firms in the country, and they lost. What can Dr. Grayson do? I'm going to show you what Dr. Grayson did. So let's see what the judge ordered on this case, which of course is a public record. Ordered the defendant's motion for leave to renew and is granted to the extent that the October 11, 2012 order is vacated. So we were successful. Now, depending on the case, and we didn't really talk about this, the motion to vacate, you can do multiple motion orders to vacate. You can do multiple. And sometimes, depending on where we are in the case, I might do multiple. But if I think the judge is very biased and it's going to be a waste of time, we don't. But if the judge seems reasonable and not like he's on the take, then we will keep doing it. And this is a case where they've already done multiple motion to vacate. I'm coming in with a new one, right? But it was very successful. You see here, the motion to vacate was ordered, but let's keep going because there's more. It is further ordered, that the plaintiff's amended complaint is dismissed in its entirety. Because I'm going behind 2 Wall Street law firms, I couldn't mess around. Sometimes I do stuff to feel out the judge and see if the plaintiff will resolve amiably. Okay? I want to see if the plaintiff is going to wake up and give you low mod. And that's quick and painless. But in this case, I couldn't. So everything that I'm mapping out to you today, I put it in a 100-page document. This document was crazy. Even if you threw out 10 of the things, there was 100 things that made it impossible for the judge to throw them all out. If the judge just ruled in favor of one of those things, he had to throw the case out, which is what happened. And in addition to that, you can see here it's ordered that the plaintiff their cross motion for sanctions is denied. This attorney, this law firm was very unhappy with our motion. So what they did was to scare the client. They filed for sanctions. They asked for $50,000 in sanctions because they called this a frivolous lawsuit. They said, Your Honor, he's hired 2 Wall Street law firms, and now he's coming up without no attorney and filed this lengthy motion. It's frivolous. We want damages. We want sanctions for $50,000. Can I tell you something? The client was very unhappy with me. The client was calling. He was kind of nice, but he was kind of not nice because he was like, in addition to losing my house, now I got to come up with $50,000 to pay sanctions. But I said, listen, man, just relax. Stay the course. Most of my time dealing with clients is telling them to relax and stay the course because we always have an exit strategy. But in this case, as you could see, it turned out in the client's favor.